From the Appellate Division of the Public Defender's Office. I'm here today on behalf of Ms. Rebecca Davis, the appellant in this matter. With the court's permission, I will reserve 4 minutes for rebuttal. I will spend most of my time today focusing on the due process violation that occurred in this case when the trial court permitted the state to comment upon and misuse the defendant's exercise of her Fifth Amendment right to remain silent after she heard Miranda warnings. Time permitting, I will also touch upon why Ms. Davis was entitled to a judgment of acquittal as to the charges of aggravated child endangerment and aggravated child neglect. And we will ask the court to set aside those convictions and to remand for a new trial as to any remaining counts. Due process prohibits prosecutors from pointing to the fact that a defendant was silent after she heard Miranda warnings. That language comes verbatim from Salinas versus Texas. That is the U.S. Supreme Court's most recent case reaffirming the constitutional principle at issue in this case. And what that constitutional principle means is that the state is not permitted to comment upon a defendant's post-Miranda silence during opening statements, and it means that the state is not permitted to bring in evidence of the defendant's post-Miranda silence in pursuit of its goal to secure a guilty verdict. And yet those two things are exactly what occurred in this case. In opening statements, Ms. Davis, the state told the jury that Ms. Davis was summoned to the sheriff's office and she chose not to give a statement to the police. The state used Ms. Davis's post-Miranda silence to establish the theory of its case, which was that Ms. Davis was unhelpful, uncooperative, and provided no information, first to the medical providers that were treating her child, and then to the police who were investigating the child's injuries.
Mr. Gill, let's say that the police had simply knocked on her door, asked her, would you be willing to speak with us about the incident? And she says, no, thank you, not interested in speaking with you. Could the state have mentioned that at trial?
Yes, Your Honor.
Okay.
In that situation, the principle at issue here, which was developed in Doyle versus Ohio and has been reaffirmed subsequently, would not apply because, if I'm not mistaken, there were no Miranda warnings.
Very good. So what if Miranda is not required? So in this case, I don't understand your client to have been in custody. And so at that point, the Miranda warnings would not have been triggered as a matter of constitutional law.
That is correct, Your Honor.
So the argument here, and I suppose the argument adopted by Kentucky, is that even if Miranda is not required, if an officer is administering the Miranda rights as a belts and suspenders measure, that at that point, that's when the, I guess the constitutional privilege not to have your silence commented on at trial attaches, even though Miranda itself wasn't required?
Correct, Your Honor. And candidly, I do believe this is an issue of first impression in Tennessee where you have...
Are there other courts other than the Supreme Court of Kentucky that have gone that far?
Yes, absolutely, Your Honor.
Okay,
and we've cited those cases in our brief. The weight of authority on this issue says that it is the Miranda rights. It is the giving of the Miranda warnings that causes this due process protection
Even when they're not required?
Even when they are not required. When they are given in an abundance of caution, as appears to be the case here.
Why is that the case? So if Miranda is not required to be given to dispel the coercion of an interrogation, why is it that at that point then this privilege follows?
Well, it goes to the underlying basis for this entire principle, which is that when an accused is given Miranda warnings, those warnings constitute an implicit promise that invocation of the Miranda rights will not then be met with the use of the exercise of those rights against the defendant at trial. That language is almost verbatim from Doyle versus Ohio.
Even though the officer was not required to give Miranda, and had the officer not given Miranda, this wouldn't even be an issue?
Correct, Your Honor. Okay. But Miranda warnings were given, so that's not the case.
Do you think it would make a difference, because I've seen this before, where someone voluntarily comes in and the officer then says, these are your rights, but at the very beginning of reading the rights, even though it says you're under arrest, he marks through that, it says you are not under arrest. So do you think that changes it? Because Miranda starts out, as I understand from the Supreme Court, you're under arrest. So if you say to him, you're not under arrest, then is that really Miranda warnings? I know
as
that's
long as
speculation.
the-
I'm just giving you a hypothetical.
Absolutely, and I'm happy to engage with that hypothetical. Based upon the underlying rationale for this rule, as long as the Miranda warnings are given, even if the Miranda warning incorrectly says somebody is under arrest or does not say that they are under arrest,
Or is not required.
or is not required, as long as the person, as long as the accused is informed that they have the right to remain silent and so forth, as long as they are informed of those rights, that triggers the implicit promise of Miranda, which is that it will not be used against you at trial. And that comes from Doyle versus Ohio. To circle back, Judge Greenholz, you asked if other courts had addressed this. We have cited several other cases, Finkel versus Abrahamson from the Seventh Circuit, State versus Plourd from the Connecticut Supreme Court, and State versus Finkel from the Wisconsin Supreme Court. All of those cases reached the same conclusion. And I will reiterate the statement from the U.S. Supreme Court that I mentioned earlier in the Salinas case. The U.S. Supreme Court said that it was the Miranda warnings, that it's after the defendant hears the Miranda warnings that this attaches. The Supreme Court specifically mentioned Miranda warnings. Now, admittedly, in that Supreme Court case, we didn't have this specific scenario, but nevertheless, the court pinned this right to the giving of Miranda warnings. I will note, Judge Greenholz and Your Honors, that the state does not dispute this on appeal. At the trial level, the trial court initially said that because there was no custody, that this was no problem, that there was no due process issue here. The state has not disputed this issue on appeal. In candor, I will say, even though the state has not cited this case, I'm aware of one case that goes the other way. There's a case from the Maine Supreme Court. To my knowledge, that is the sole case that has said that when there is no arrest, that this due process principle does not apply. And I think the Kentucky Supreme Court, in the case that you referred to, Bartley versus Commonwealth, does a good job of explaining why the reasoning in that Maine Supreme Court case is dead wrong, and that the reasoning in all these other cases is correct. And I will note that that was one of the reasons why, as I just mentioned, the trial court said that this was no problem for the state to mention this in the opening argument. We contend that that was simply incorrect, that it was a due process.
I'm sorry, Doug. Let me ask another question, because I seem to kind of figure out a reference to that in perhaps something the state has written. If you have a situation clearly where the officer has interviewed someone and clearly they're under arrest and clearly they have been given their Miranda rights, and then during examination of the officer, the defendant's attorney is suggesting that the officer didn't do anything to investigate the case, didn't talk to the defendants, didn't do anything. So does that open the door for the state then to put on proof that indeed I talked to the defendant and the defendant refused to give a statement?
Yes, Your Honor. There is this narrow exception to the general principle of the state not being permitted to mention post-Miranda silence, and opening the door is one of the exceptions. We know that from the Tennessee Supreme Court's decision in State versus Dotson. In Dotson, we had exactly the scenario that you described, Judge Montgomery, where one of the state's main tactics at trial was to impugn the investigation of the police. And so in that scenario, the Tennessee Supreme Court said, you open the door. You open the door to this. Likewise, if Ms. Davis had gotten up and testified and said, the police never gave me a chance to explain myself, I was never given any chance to explain myself, then that would open the door. But
That's not the case here, though, right? Because the state mentioned it in its opening statement.
exactly.
Right.
It's impossible to have opened the door in opening statement. And moreover, the defense never opened the door. Ms. Davis never opened the door to this kind of thing. There was no suggestion of impugning the adequacy of the investigation in this case.
Some would suggest the state was being preemptive. But
Perhaps, I mean, did defense counsel?
I meant that in jest. I was not really serious. I have no idea what the
No, that's exactly
thought process was.
the prosecutor said.
Even if Ms. Davis did not open the door, did defense counsel open the door through argument otherwise?
No, Your Honor. And in fact, on the contrary, defense counsel provided every assurance to the court that as an officer of the court, they would not open that door. So defense counsel said, we will not impugn the state's or rather the police investigation, the sheriff's investigation in any way. And this notion of preemptively opening the door implies that the door must open first, to state the obvious. And the door never opened. Defense counsel said that the door would never open. And so this case is plainly distinguishable from Dotson on those grounds. While we're on the topic of narrow exceptions to this rule, there is another one that was recognized by the U.S. Supreme Court in a case called Greer versus Miller. In that case, you had a situation where the prosecutor asked a question that elicited information about post-Miranda silence. The defense immediately objected, and the trial court sustained the objection, told the jury to disregard the statement, told the jury that they were not allowed to make any inferences based upon that. In that situation, the court said, there has been no constitutional violation here because the trial court acted quickly and made it so that the jury was not able to draw any inferences from the defendant's exercise.
But in this case,
directions.
defense counsel didn't say anything when
Pardon me, Your Honor?
Did defense counsel say anything during the opening statement when the attorney?
Well, in the opening statement, the state just launched that
I understand,
out
but did the,
and immediately objected. The defense counsel immediately objected, appropriately in a bench conference outside the presence of the jury.
did the judge give an instruction?
The judge immediately said that there was no due process violation, and so he would not give an instruction.
Okay.
And so defense counsel didn't even have a chance to request an instruction because the trial court preemptively said that it was not going to provide an instruction. Now, the trial court changed its mind a little bit as this issue progressed throughout the trial. And later on, the trial court said, well, maybe an instruction is appropriate. This was when it was hashed out yet again before the officer testified. Ultimately, however, what the trial court decided to do was to merely give the pattern instruction about the defendant's choice not to testify at trial. And so we're all familiar with this pattern instruction. Ms. Davis has chosen not to take the stand today. But while this court should certainly presume that jurors have common sense and would follow instructions, I don't think you can presume that they are constitutional scholars and that they are aware that the same right to silence applies with pretrial interactions with the police as would apply to not taking the stand at trial. And so unlike past cases, there was never any instruction given here that limited what the jury could infer from this. And moreover, I think it's very telling, something that the state conveniently omits from its brief. One of the reasons that the state insisted that it was entitled to bring in this evidence is because it was part of the prosecution's story. It was part of the prosecution's story that Ms. Davis failed to provide information to the medical providers at the emergency room. She failed to provide information to the pediatric experts at Le Bonheur, and then she failed to provide information to the police when she was given an opportunity to do so. What the state basically admitted there was that they used this to secure a guilty verdict. And that's exactly what the due process clause forbids, and it's exactly what happened in this case.
Let me ask you a question that I wrote when I was reading the state's brief. They indicated in a footnote that you did not contest the sufficiency of count 1, the aggravated child abuse.
That's correct, Your Honor.
So let's just say, for the sake of argument, you're unsuccessful on your other claim, the Miranda claim. Are you conceding then that the proof is sufficient for count 1?
For count 1 only.
Okay.
Yes, Your Honor.
Let's suppose you are successful on your Miranda claim, and the state makes the argument of harmless error. And it sounds like you're almost agreeing, you probably wouldn't come right out and say it, that there's overwhelming proof for count 1 anyway. Is that your position?
No, Your Honor, I did not say that. Essentially looking at, and just to answer your question directly, we concede that the proof is minimally sufficient.
It's not overwhelming.
As to count 1. I know overwhelming is the favorite word of my friend on the other side, but I would say that the proof here is not overwhelming, it's not regular whelming, it's barely whelming at all.
Barely whelming. Okay. New
To
term.
use some non-words
I've learned
here.
2 new terms, Bristol briefing and barely overwhelming today.
No, not overwhelming. Barely whelming.
Barely well.
Underwhelming, in
Sorry,
fact, but minimally
underwhelming.
sufficient. And I'll be candid with the court as to why I made that concession as to count one. If we look at a case you may have heard of called State versus Durantes, that was a child abuse case.
Right.
And the principle we get from that case is that when you have injuries that are readily apparent, that are very obvious to any caretaker, any competent caretaker, and when you have some proof that both parents or two people are taking care of the child, in that scenario, the court in Durantes said that the jury may find both of those caretakers guilty, either for having inflicted the injuries or for being criminally responsible. And so I felt like we were kind of pinned down by Durantes in that situation. I think pre-Durantes, there would be insufficient proof as to any of the charges in this case. But that child abuse charge in count one is very different from the child endangerment charges in counts 2 and 4 and the child neglect in count 3. And we contend that that the proof in the state's case in chief, which is all that matters here under the standard of review, is insufficient as to all those charges. And I'll just mention in my final seconds that it's especially insufficient as to counts 3 and 4 because the proof was undisputed at trial that those injuries were not apparent, that the rib injuries and the leg injuries would not be noticeable by a competent caretaker. For that reason, we ask that this court set aside the convictions in counts 2 through 4 and remand the remaining count for a new trial. Thank you.
General?
Good morning again, Your Honors, and may it please the court. Ronald Coleman on behalf of the state. This court should affirm the judgments in this case because because the trial court properly allowed a single statement about the defendants declining to give a statement, and because the evidence was sufficient to establish guilt in all 4 counts. Turning to the first issue that has been presented today with this due process claim, this court can affirm the judgments in sort of 3 ways. I think one is to your point, Judge Greenholz, of there's this distinction, or there is a distinction between Miranda being required or just being given out of an abundance of caution. And frankly, the state didn't brief it. We aren't, excuse me, we aren't conceding that Miranda should have been given or that this is implicated. That just wasn't fleshed out in the trial court. And so it's an issue of first impression, maybe, that wasn't really preserved below.
I mean, the state's brief jumped immediately into harmless error analysis.
Not harmless, no. We don't think it's a Miranda violation, or we don't think it's a due process violation. So first, this court could dive into whether there's a distinction and if Miranda is not required, if due process is ever implicated. But even sort of assuming that anytime you give a Miranda warning, even if it's not required, the due process is implicated. The reason it's not a violation here is because that wasn't exploited upon by the state. So this passing comment, and the state clearly told the court why it wanted it in there, was to explain that the police had done an investigation. And we're not trying to get in there. Judge Montgomery, you asked a question as to whether the defendant had opened the door. That's not the theory by which the state is arguing this should come in. The defendant, I think we would agree, the defendant did not open the door to allow the state to sort of rebut that or sort of, slam it open. Instead, the state has to prove its case beyond a reasonable doubt to the jury. And it can be proactive in doing so by establishing that officers did a thorough investigation.
But why couldn't they just ask that question? Why did they have to go down this path? I've got to believe, when I read this record and the statements of the state's attorney, I thought, I'm really interested to see how you were going to justify that at this argument. I mean, you cannot be happy with the state's attorney here and throwing that out there in opening statement.
I think it certainly could have been much better. Ultimately the state didn't exploit this to the dangers of Miranda, or the reason that Miranda is in place is because we don't want to have the jury infer that silence means guilt. And so if the state got up there and was like, she was quiet, she didn't tell you her part of the story, that is inferring guilt. Instead, what the state did is it didn't matter what the statement meant to the defendant. What it mattered was that this officer did their job and because ultimately what you have here is a child victim who, over the course of 6 days, suffered significant amounts of injuries.
No question.
And
Facts
so
are bad.
to the state, the jury's going to be asking, who all did the police go and talk to? How did they investigate this to sort of narrow down the people that they thought it was? Did they even talk to these parents? And so that's the question was, did you go, what sort of investigation did you do? Well, I talked to the grandparents, I talked to some other people. Did you ever go and talk to these parents? Well, I went to the house and, they either weren't there or they didn't want to talk, so we scheduled a meeting. Okay, well, did they ever come down? Yeah, what happened? They declined to give a statement. Move on. You've done your valid investigation. The state was using it to show, didn't matter if they declined to give a statement or if they said anything. What mattered was that showed the officers had thoroughly investigated the matter, had gone and questioned people.
But couldn't that principle, I'm not saying it's right or wrong, but couldn't that principle apply to any case in which an officer talks to a potential suspect?
I think it depends on sort of the purpose. Again, under Dotson, the due process is implicated if Miranda is given and arguably necessarily, and the state exploits that at trial. So if the state makes an argument of the fact that they declined to make a comment is bad, that means that they were guilty because they can't explain they can't give you a different story, that's exploiting it. If it's only to bolster, and the trial court very clearly stated that was the sole purpose. The defendant, my friend on the other side, comments that the state offered up other bases for why it should come in, and the trial court is very explicit that this was only coming in to show that the officer had done an investigation. So the state's position is that by failing to exploit this, or by declining to exploit this and suggest to the jury that the defendant's silence in some way made her guilty or inculpated her, then there is just no Miranda violation. But even if sort of the third way.
That's the natural inference though, right? And isn't that exactly what the state was using it for? It's natural inference. I mean, the natural inference is that, well, if you didn't have anything to hide, you would have spoken with the investigator.
I think the state, when it offered up options, certainly would have loved to have done that and to have continued making that argument, to the jury in closing or fleshing it out. But that's not the purpose of
Didn't the state do that in closing though? I mean, your friend on the other side, and I thought that I remembered this too, but your friend on the other side said it was basically kind of like a theme. It's like the defendant is not cooperating in the care of the child, and then the defendant's not cooperating here, then the defendant doesn't cooperate with the police later on.
So that was the general theme, is this sort of uncooperativeness of the defendant. But they did not exploit this at closing argument, Your Honor. And so our position is that they never exploited it throughout trial. The closest you might get is opening statements, but even then, that's just giving, here's what the officer's going to testify about his investigation.
But at that, I'm sorry.
Go ahead.
At that point, the issue of a poor investigation hadn't even been mentioned or raised, correct?
Well, it doesn't have to be, Judge.
So you're anticipating what the defense is going to be.
Correct, and the state gets to be proactive in proving its case beyond a reasonable doubt. The defendant maybe could have sandbagged and not talked about a poor investigation until closing, and then the state wouldn't be able to put on any proof because it's not a fortune teller. And so instead, it's allowed to put on its proof and prove its case in a way that it deems necessary, and that includes establishing that police did a thorough investigation.
But in the state's rebuttal closing, they always have the ability to say, what proof did we hear that this was a poor investigation? Zero.
I think you can, but that's sort of a weak argument. The state's allowed to bolster it with proof proactively. But even if this court were to determine that this does implicate due process, that this somehow rises to the level of exploitation by the state, the defendant's not entitled to relief because it was harmless. The proof here was overwhelming.
Harmless beyond a reasonable doubt.
Harmless beyond a reasonable doubt. The burden is on the state to prove it was harmless beyond a reasonable
And
doubt.
the only real issue here is the fact that Miranda was given, and if let's say that there was never any issue with Miranda, the state is free to say it from the get-go, we met with them and they refused to give a statement.
Exactly, Your Honor, and that's
Is
why
that- is that
if this
the-
court wants to get to the sort of the first issue of what's the distinction, I think it could carve out an exception and say that when Miranda is not required, we aren't going to hold this constitutional standard as high, because that would otherwise incentivize police officers to not give Miranda warnings. And what we want is police to inform individuals of their rights before questioning, even when it's a non-custodial interrogation or when it's just meeting out on the street. So we want to, instead of incentivizing them from not giving Miranda warnings just in case so that they can use these statements, we want to say, well, if Miranda wasn't required, then it makes sense that this abundance of caution doesn't change this abundance of caution does change the examination.
So your friend suggests there's only one court of last resort, I suppose, that has gone that way, and that's the Supreme Court in Maine. Are there any other cases?
Not that I'm aware of. To be frank, again, because this wasn't fleshed out in the trial court, we sort of went straight to this, so I have not investigated, done a 50-state survey. But even if there is one state versus others, this court can carve out an exception.
But the weight of the authority, I guess, we all would agree the weight of the authority is on the defendant's side in this case.
I think given the cases that he cited to, without being able to double check, probably. But again, even if this court finds that the fact that Miranda was given even when it wasn't required implicates due process and that the state then exploited it, it's harmless beyond a reasonable doubt because it did not move the needle for the jury. This was a singular comment in opening, which the jury was expressly told is not to be considered as evidence, and then a passing comment by a police officer talking about her investigation into the incidents. That's not why the jury returned guilty verdicts. The jury returned guilty verdicts because the defendant and her boyfriend, over the course of 6 days, inflicted multiple injuries on this young individual. So we would submit that, any of those three ways this court can affirm, but certainly the error is harmless beyond a reasonable doubt. Turning briefly to the defendant's claim that the court should have granted a motion for judgment of acquittal. At first, I do have a bit of a mea culpa to admit. In the reply brief, as the defendant notes, in the state's analysis of this issue, in our string citations to the record, we include several citations to portions that occurred after the state rested. That's not proper for a motion for judgment of acquittal. I will note the state rested on page 198 of the transcript, so it's real easy. What this court can do is go and just strike anything that was after page 198. To the extent that my friend on the other side suggests that we have waived this or failed to provide citations to appropriate authorities, I would strenuously disagree. Every single citation, even if it includes that citation to something after page 198, contains multiple references to the state's proof that was put on before it rested, which establishes the defendant's guilt. And so this court can rely on that, and we certainly haven't waived it. We've made appropriate references. We just made an inappropriate reference or two. And so we ask that you strike those references, but the issue certainly
Your position would have been correct had the defendant offered proof, but in this case, the defendant offered no proof.
Correct.
Right.
Exactly. And so, yeah, we erroneously cited to additional portions of the transcript, but that in no way negates our citations to the proper portions of the transcript. And turning to the sufficiency of the evidence, it overwhelmingly established the defendant's guilt of all 4 counts. And I think it's important to note that each count had a separate action, charged a separate act committed by the defendant. And so with regards to count 1, the aggravated child abuse, the victim suffered significant injuries, broken arm, and other acute injuries, and the jury could have easily found that when he was in the sole care and custody of the defendant and her boyfriend, that the defendant inflicted some of those wounds. Count 2 charged aggravated child endangerment for exposing the victim to those acute injuries. And the jury could have found that while the defendant inflicted some of them, she also allowed her boyfriend to inflict the other ones. That's just a rational inference that the jury could have made. So those are 2 separate counts for those. And then as to count 3 and 4, the defendant was charged with aggravated child neglect for failing to seek treatment for the victim suffering broken ribs and a broken leg. And I'll push back a little bit on the defendant's claim that this could not have been discovered. What the doctor testified was that this is tricky, but what you're going to have when the victim suffers these injuries is crying, discomfort, other signs that could have been picked up. So while it's not readily and immediately apparent to anyone, the jury could have inferred that this should have been apparent to the victim's mother and that she neglected to get him treatment and health after that. And then there was a deleterious effect because there's proof the defendant's broken bones did not begin to mend until they were treated and wrapped by medical professionals. And then finally, count 4 involved aggravated child endangerment for failing to protect the victim from the aggravated child, from the prior injuries. And again, the jury could find that maybe the boyfriend inflicted those and she failed to protect the victim from those injuries.
I thought that the argument on count 3 was a little more nuanced. I thought that the argument was that the state could not rely upon serious bodily injury that was essentially the broken bones, essentially the serious bodily injury that resulted from the child abuse, that there had to be additional serious bodily injury there. At least that's what I thought was being argued. If that's what's being argued, what's the state's response to that?
So I don't think the state has to establish serious bodily injury, even additional serious bodily injury, to establish child neglect. What the state has to prove is a deleterious effect from the infliction of those original injuries. And again, with proof that the broken arm, which was an acute injury, did not begin healing until it was treated and wrapped, even with the experts saying that the injuries, the broken ribs, the broken legs, were in various stages of healing, the jury could take other testimony and say the victim suffered a deleterious effect from failing to be treated for these broken ribs and broken legs up until the point, at least up until the point where they were treated.
And then how's that different from the abuse?
Because the abuse was for the acute injuries. So there are 2 distinct categories of injuries. So there's the deleterious effect from the failure to treat the broken ribs and the broken leg, and then there's the abuse by inflicting the broken arm, the bruising to the head, the messed up eye, those things. So those are distinct injuries that the jury had to distinguish. So state submits that the evidence established guilt for all 4 counts based on the state's proof alone. And then I believe those are all the issues that have been presented to this court. If there are no further questions, we'll rely on our brief for anything else. And we ask that you affirm the judgments. Thank you.
Everybody okay? Tim?
We got rebuttal.
Oh, yeah, that's right. Are you going to be okay?
So, Your Honors, what my friend is arguing is that the state's desire to show a complete police investigation supersedes the due process clause, supersedes a defendant's right to due process. You will notice that my friend cites no authority for that proposition. There is a good reason he cites no authority for that proposition. There is no authority for that proposition. That is plainly contradicted by all the governing case law. There is literally not one case to support the notion that the state's desire to preemptively demonstrate a complete police investigation can trump the defendant's right to due process. And any such holding would be contradicted by binding U.S. Supreme Court case law. On the contrary, the only situation where showing a complete investigation becomes salient is when the defense opens the door, and my friend has rightly conceded that there was no door opening testimony or inquiry or anything by the defense. I strenuously disagree with any suggestion that the state did not exploit Ms. Davis's exercise of her right to remain silent after hearing her Miranda warnings. That is precisely what the state did in this case. My friend even acknowledged that that was part of the theme, part of the state's theory of the case.
I think what the state was saying is that we have a mention in opening and we have one passing remark in testimony by an officer, and that outside of that there really isn't much else. So what is much else?
And so those two statements, first of all, that's one statement more than is required to establish a constitutional violation, and the U.S. Supreme Court and the Tennessee Supreme Court and this court have acknowledged that in the past. And so the fact that there were 2 comments, one in opening and then returned to in the state's proof, and I would not characterize that as a passing remark. I believe that it may have been a single remark, but it landed with a great deal of impact, because it brought home the state's theory of the case that Ms. Davis had never offered an explanation. And in State versus Nora Jackson, the Tennessee Supreme Court held exactly what you suggested, Judge Greenholz, that without any limiting instruction, what is the inference that the jury is going to make from that? The natural inference is that she did not have an explanation for her role in the investigation because she has some guilt.
Is the closing argument in the record?
Yes, Your Honor.
Okay.
Absolutely. And so you'll see in the closing argument, by that point, the trial court had precluded the prosecutor from specifically referring to the statement, the controversial statement here, but the state still returned to the same theme. In particular, there was one statement from the closing where the state said they didn't give any information to the medical providers, they didn't give any information at Le Bonheur, and that is all you get from them. That's all you get from them, referring to Ms. Davis. Quickly, I will note, I do in fact make the argument that Judge Greenholz mentioned with regard to the neglect in count 3, and my friend is simply wrong. There must be proof for aggravated child neglect. There must be causal proof that the neglect caused a serious bodily injury in addition to and apart from the initial acts of abuse. The proof was undisputed here that all of these injuries were caused by abuse, including the rib injuries, including the leg injuries at issue in counts 3 and 4. And those were the only serious bodily injuries. Those were inflicted by someone's abuse, we don't know who, and there was no additional proof as to any serious bodily injury caused by the neglect. And so for that reason, the proof is not overwhelming there. We'll rely upon our brief for the other counts. And for that reason, we ask that this court set aside the convictions in counts 2 through 4 and remand the case for a new trial on any remaining counts. Thank you.
Thank you. You okay? All right. Would you call our next case, please, Madam Clerk?
State of Tennessee versus Marion Brock Foreman.